The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Thank you. Good morning. The first case is State v. Scott, and we'll hear from the appellant.
May it please the court. I'm Gordon Widenhouse from Chapel Hill. I represent William Scott in his appeal to this court from a divided decision of the Court of Appeals. I'd like to try and reserve 5 minutes for rebuttal. There is one issue and one issue only in this appeal. That is whether the unconstitutional admission of the defendant's blood alcohol content was harmless beyond a reasonable doubt. The Court of Appeals unanimously agreed that the admission of this evidence was unconstitutional. The dissent disagreed only with the majority's analysis of whether this constitutional error was harmless or prejudicial. The dissent said that the majority did not appropriately apply the standard of harmless beyond a reasonable doubt. The dissent was correct, and we will ask this court to reverse the decision of the Court of Appeals. This case is not about whether there was error in the jury instructions. This case is not about whether the verdict was ambiguous. This case is not about whether the evidence was sufficient to go to the jury. And this case is most certainly not about whether there was plain error in the case. The constitutional objection was made pre-trial by motion to suppress. It was ruled on by the trial court on the merits. It was renewed consistently during the trial. And the Court of Appeals unanimously addressed the merits of the the Fourth Amendment issue in the case.
Mr. Widenhouse, before you go any further, I've reread the Court of Appeals majority opinion several times. It's not entirely clear to me what the basis for their decision was. The dissent clearly said it was constitutional. The majority didn't dispute that. But what about the majority opinion itself suggests to you that it was constitutionally based?
Well, because they analyzed it under a Fourth Amendment analysis.
Because I couldn't really find a reference to the Fourth Amendment in there. It ultimately seemed to me to come up to say that it was based on the Superior Court order. I reread that this morning, and it doesn't reference the Fourth Amendment either. So I'm a little bit at sea trying to figure out what the basis for the decision was, even though nobody else seems to have a problem with about that.
Well, I think that maybe there was not a specific reference to the Fourth Amendment in the Court of Appeals decision because it was essentially kind of assumed that was the basis for the motion to suppress. It was argued on that basis in the briefs in the Court of Appeals, and the court looked at the in re Superior Court order. And even though my recollection of that opinion is consistent with yours, Justice Ervin, that it doesn't mention a constitutional basis, the analysis in the opinion is essentially a constitutional analysis, asking for there to be something in the request for the production of evidence beyond just, we'd like to have the evidence, which was all there was in this case. When they asked for the hospital records, they just said, we want the hospital records. And there was no suggestion of probable cause or reasonable suspicion in the request. So maybe there was a little bit of an assumption in the way that the Court of Appeals addressed the merits of the issue. But it's clear from the dissenting opinion that it must have been a constitutional analysis, because the dissenting opinion says we need to use the proper standard under Section 1415 and 1443B, that the error is harmless beyond a reasonable doubt. So, I mean, again, nobody's before this court arguing that it was a constitutional error. That's not something that's been addressed by the state. There was no request for discretionary review on the merits of the issue. I think they acknowledged that in their brief. So
They
I would
did.
say, even though it's not absolutely clear, I think the underlying premise, the underlying assumption is there was constitutional error because that was the basis for the argument and ruling in Superior Court.
Okay,
I hope
thank you.
that answers your question about that.
Yes, sir.
Anyway, this case really is about one and only one issue, and that is whether the error in this case was harmless beyond a reasonable doubt. Our position is the Court of Appeals was wrong for 5 reasons. First, the Court of Appeals put the burden on Mr. Scott to show prejudice. We can see that from references on pages 15 and 16 of the slip opinion. On page 15, they say the defendant cannot show error in this case. On page 16, they say the defendant has failed to carry his burden to show any prejudice. So clearly the majority put the burden on Mr. Scott to show prejudice. That's inappropriate under the statute. Section 1443B plainly says the state has the burden to show the error was not prejudicial, was not harmless. So the first error in the Court of Appeals majority's analysis was improperly putting the burden of showing prejudice on Mr. Scott. The second error in the Court of Appeals analysis was the standard of prejudice itself. They didn't mention harmless beyond a reasonable doubt. They simply looked at whether the evidence might have been prejudicial. That's a 1443A analysis. Applies when the
Again, to go back to their decision, I couldn't find a place where the Court of Appeals stated what standard it in fact used. Am I wrong in missing that?
No, I don't think you are, except that the dissenting opinion said there's not harmless beyond a reasonable doubt analysis in the majority's opinion. I think you're correct.
Majority doesn't say whether it's using plain error, 1443 or 1443A error. All it says that I could see was that they put the burden of proof on the defendant.
Well, I think that's right, but by putting the burden of proof on the defendant, 2 things happen there. One, it's not plain error. They're saying the defendant's got some burden here. They didn't say he's got a burden to show the added prejudice that's required from plain error. There's no mention of plain error in the Court of Appeals opinion. There's no citation to a plain error case. And the dissent doesn't say the majority is inappropriately applying plain error. Now, granted, the majority doesn't cite 1443B or 1443A, but it's analysis of saying the defendant's got to show some prejudice, which he hasn't done, is a 1443A type analysis. And by doing a non-1443B analysis, they're not using the harmless beyond a reasonable doubt standard. And that's specifically what the dissent disagrees with, that we're supposed to use harmless beyond a reasonable doubt because it's a constitutional issue. The majority hasn't done that, so they dissent. So that is the issue before the court. Again, if the Court of Appeals majority opinion could perhaps have been clearer, but the lack of clarity isn't the issue before the court. The question is, did they apply? Did they put the burden of proof on the right party? And the language of the Court of Appeals clearly indicates they did not. And they have to put the burden of proof on the correct party with the correct standard. If they're putting the burden of proof on the defendant, they're using 1443A, which means they're not using harmless beyond a reasonable doubt. So again, our position is the second problem with or error in the majority's opinion is the failure to use harmless beyond a reasonable doubt. The third error or problem with the Court of Appeals analysis is the majority tends to conflate the violation of a motor vehicle law with malice. And when the defendant is charged with what I call second-degree murder by driving or second-degree murder while driving, there are multiple elements to that offense. One of those is a violation of at least one motor vehicle law. But there's a separate element. I think it's basically element number 6 when you use the pattern jury instructions, and that's proving malice. And you have to prove not just the violation of one or more motor vehicle laws, but that the violation of those laws was done with malice. And the Court of Appeals majority tends to merge or conflate those two and seems to say, if you violate a motor vehicle law, it would have been done with malice. And they don't do the appropriate analysis of looking at malice separately. And that leads to what I think is the fourth error in the majority's opinion. They tend to conflate sufficiency of the evidence with the absence of prejudice. And those are two completely distinct concepts. Sufficiency of the evidence means we take the evidence in light most favorable to the state. We take all the inferences in favor of the state, and we ignore any contrary evidence. And the appellate court asks itself, is there enough evidence here to go to the jury, taking the evidence in light most favorable to the state? Prejudice is a different thing. Prejudice essentially asks, did the inadmissible evidence put a finger on the scale that would have led the jury to convict that the jury might not have done without the evidence? That's not a sufficiency of the evidence analysis. That's a prejudice analysis. And that analysis, that type of prejudice analysis, is what this court talked about in its very recent case of State versus Bowman, which is about a year and a half ago. And the court wrapped itself in Bowman, said the question really here is, would this evidence have contributed to the jury's verdict? And the Court of Appeals didn't look at it that way, and they didn't look at it that way because they conflated sufficiency of the evidence of a violation of a motor vehicle statute with whether the inadmissible evidence was prejudicial in the case.
You had an interesting way of looking at it in your brief. As I looked at your brief, you said that the evidence of second-degree murder was far from overwhelming in the absence of the .22 blood alcohol content reading, and that speeding and reckless driving don't, quote, necessarily, unquote, show malice. Is that careful choice of words on your part a concession that defendant's second-degree murder conviction can stand without that blood evidence?
Well, my answer to that would be, well, I like the idea that you consider it carefully worded. I hope that's a compliment. I'm not conceding that the evidence was sufficient to go to the jury in the absence of the .22 blood alcohol content. That would be a different issue. But here, any sufficiency argument would have to include the .22 blood alcohol content, because the state gets the benefit of all the admissible and inadmissible evidence on a sufficiency question.
But your work does make it appear as though you're carefully recognizing that while you reserve the opportunity to say that the .22 blood alcohol content reading being admissible was prejudicial, on the other hand, that the speeding and the reckless driving, because they don't necessarily show malice, nonetheless are sufficient to stand alone. I was looking for clarification on that in light of your analysis.
I think, well, I'll answer it two ways. One, I think if I were trying to argue sufficiency of the evidence in the absence of the .22 blood alcohol content, I'd have a difficult argument because the standard of review is much more difficult than showing prejudice. The standard of review would be you take the evidence in the light most favorable to the state and ask yourself, could the jury have convicted on this evidence? And arguably, in the absence of the .22, perhaps the jury could have convicted. Perhaps that would have been enough evidence for the jury to say there's malice in this case, in addition to the violation of the motor vehicle statute. I mean, one of the difficulties with the whole prejudice analysis in this case, and the difficulty with the Court of Appeals is conflating the violation of the motor vehicle statute with malice is a murky concept. The pattern jury instructions tell the jury you want to ask yourself, does the defendant, did his actions evidence essentially a heart devoid of social duty? did he do something so reckless that he didn't exhibit a value to human life? And perhaps if the jury was asking itself, okay, well, we think the defendant was speeding in this case, and we think he was speeding at this particular rate, and we think that he was crossing the yellow lines and passing improperly and wasn't doing a proper lookout and watching what he was doing, the jury might find that to be malicious. They might find that to be a heart devoid of social duty or an unreasonable caring about human life to drive that way. Again, whether the evidence was sufficient is not the issue in this case. Okay, the question under Bowman is whether this inadmissible evidence, and I want to be frank about it. The blood alcohol content in this case was almost 3 times the legal limit. And I think it's a tough argument to suggest that a jury wouldn't consider that a driving fast while you're intoxicated almost 3 times the legal limit to be malicious conduct. And if that's what the jury did, if that evidence of 0.22 blood alcohol content put a finger on the scale, as Bowman says, it couldn't have contributed to the conviction. It's almost incomprehensible to me that the 0.22 blood alcohol content wouldn't have contributed to the jury's determination.
Is another way, just to make sure I'm following you, Mr. Whitehouse, is another way of saying what you're saying in response to Justice Morgan's question, to say in effect that the presence, regardless of whether there was sufficient evidence to support the submission of the issue of the defendant's guilt of second-degree murder to the jury based upon speeding or reckless driving, it is more likely that the jury would actually find the necessary malice with the 0.22 blood alcohol content level in the record than without it.
I think you said it much more clearly than I did, but yes, that's
I doubt that, Mr. Whitehouse, but at least I understood you to be saying.
Yeah, again, it's very difficult for me to envision that 12 lay people sitting in a jury deliberation room trying to decide whether a person speeding and passing yellow lines was done maliciously wasn't impacted by evidence that he had a blood alcohol content of 0.22, which is why I think ultimately our fifth point is the Court of Appeals just didn't apply harmless beyond a reasonable doubt in the stringent way that this court has said it is supposed to do. I mean, this court has said in Wilson it is a demanding test. It said in Bowman there has to be no reasonable possibility that the evidence did not contribute to the conviction. No reasonable possibility that a blood alcohol content almost 3 times the normal limit didn't contribute to the jury's finding that.
I may be getting confused now, but I thought the standard, the constitutional standard, was harmless beyond a reasonable doubt. In other words, you could not find harmlessness unless there was no reasonable doubt, but that the jury would have convicted even if the evidence had not been admitted.
I think yes, no. Yes. Okay. I think there has to be no reasonable possibility, no reasonable, which is
isn't reasonable possibility the 1443A standard?
Well, I think I'm quoting almost verbatim from Bowman, and said no reasonable possibility that the evidence might have contributed to the conviction. And I think we're saying the same thing, is there can't be any feeling on the part of the reviewing court that this evidence didn't contribute to the jury's verdict. It can't have put the finger on the scale in favor of conviction. And that's plainly what it did in this case.
And at least I understand. Sorry for interrupting you so consistently, Mr. White, but just want to make sure I'm understanding you. The non-constitutional standard for preserved error, as I've always understood it under 1443A, is there any reasonable possibility that the error contributed to the outcome, whereas the constitutional standard reverses the burden of proof, puts it on the state rather than the defendant, and instead requires the state to prove there is no reasonable doubt as to whether the error contributed to the conviction.
Well,
is that right?
I think that's right, and I think we're saying the same thing, and I think that's one of the difficulties in trying to separate out the burden of proof of prejudice and what prejudice really is, what amounts to prejudice. And the most important part, distinction between 1443A and 1443B, the difference between preserved evidentiary error and preserved constitutional error, is really which party has the burden. And the burden on the state on 1443B is to show beyond a reasonable doubt that it didn't contribute to the conviction. And maybe I'm misreading Bowman, and if so, that's my fault. But I believe Bowman says that what that means that there is no reasonable doubt about the effect of the evidence is there is no reasonable possibility at all that it might have contributed to the conviction. That's proof beyond a reasonable doubt that the error is harmless. The Court of Appeals didn't apply that in this case. Again, I think if we think about it, the idea that the jury heard, and we know the jury considered this evidence of the blood alcohol content because they convicted of felony death by vehicle. And that crime requires the jury to find impaired driving by intoxication. So by convicting of felony death by vehicle, the jury necessarily found impairment by alcohol. And so they found it there, which means they were thinking about it and considered it. And that, I think, is essentially the sort of icing on the cake, so to speak, that this evidence in this case would have contributed to the jury's conviction, would have contributed to the jury's determination of malice, and put its finger on the scale unfairly in favor of conviction. So based on that, we think the Court of Appeals was incorrect, the dissent was correct, and we would ask this court to reverse.
Thank you, counsel. We'll hear from the appellee.
Ms. Haycock, you're muted. Fred, I'm still unable to hear Ms. Haycock. Are you able to hear her?
She was still shown as muted, and she's still shown as muted right now.
She's going back and forth between muted and not muted.
It looks like you're off mute now. Go ahead and say something, Ms. Haycock.
Good morning, this is Catherine Haycock.
Great, we can hear you now. Thank you. Go ahead, ma'am.
Thank you. I apologize for that technical difficulty. This is Catherine Haycock from the Attorney General's Office on behalf of the state. Justice Ervin, to go back to your point about the majority opinion, the state would contend that it's not clear that the majority found that this was a constitutional error. The word constitutional and the Fourth Amendment don't appear anywhere in the majority opinion. They do analyze both statutes, 8-53 and 90-21.20B, and find that they both require reasonable suspicion or probable cause, but that's based on the in re superior court order. So it's not really clear that the Court of Appeals majority did find a constitutional error in this case. And they do also cite the state's argument that this blood was drawn by the hospital for purposes of medical treatment, that there was no law enforcement officer present at the hospital, and that the law enforcement did not ask about the samples until 5 days after the crash.
Ms. Haycock, I'm sorry to interrupt you so early in, but I just want to ask you about the constitutional issue. Even though the Court of Appeals doesn't mention it specifically by using the words Fourth Amendment, they do say that the order is not based on either reasonable suspicion or probable cause. And isn't that the essence of the constitutional violation argued by the defendant?
Well, Your Honor, I think they're reading that probable cause or reasonable suspicion standard into the statute, and they're saying that the trial court.
They don't say that either, though. In that one sentence, where they just say the order is not based upon either reasonable suspicion or probable cause, they don't say what that is in reference to in that sentence.
Right, I agree this is not really clear, and the state would welcome additional briefing if we need to delve further into this issue about what the majority opinion found. But it's the state's position that whether the standard is harmless beyond a reasonable doubt or prejudicial, that there's no reasonable doubt that the jury still would have convicted the defendant of second-degree murder.
All right, Ms. Haycock, again, just to sort of clear brush a little bit before we get to that issue, the state doesn't contend, does it, that the defendant failed to properly preserve his challenge to the addition of the blood alcohol content, does it?
No, Your Honor, the state does not contend any kind of waiver. And I think the benefit of the Malachi and the Boyd cases is to show that the defendant the fact that the defendant failed to object when he should have supports the lack of prejudice or the harmless beyond a reasonable doubt. And it also shows that a conviction can still.
Tell me why that's the case, because it seems to me that those decisions go to the issue of whether the erroneous submission of a theory of guilt not supported by the evidence is prejudicial. How is that the same question as this, or how does it bear upon the question that we got here?
Your Honor, the state would contend that the fact that the defendant failed to object to that instruction again goes to the harmlessness, because he could have objected to that impairment instruction and didn't. But again, this is in no way a waiver issue.
Well, again, I'm just understanding that, because it seems to me that the question that we do have before us is simply, did the erroneous admission of the blood alcohol level contribute to the defendant's? I know there are different standards, but ultimately that's what we're looking at when we're looking at prejudice, I think. If the question is solely, was there harm as the result of the erroneous admission of a 0.22 blood alcohol content, how does the failure to object to the submission of other theories of guilt affect the prejudicial error analysis?
I don't think it necessarily affects the analysis, Your Honor, but the state would just point out, like the majority, that the defendant could have objected but did not. But it in no way affects the analysis. I'm sorry to keep
interrupting you, but I read this argument in your brief, and I wanted to ask you about it because, frankly, I was having some trouble understanding. And it seems to me that where we are is we've got three violations of the motor vehicle laws that supported the submission of the second-degree murder issue to the jury. The only evidence of the driving while impaired component was the blood alcohol level, apparently. But that's gone. We still have potentially evidence that you could support violations of speeding or careless and reckless driving. Isn't the prejudice analysis really whether the evidence in favor of those two theories of guilt was so overwhelming that it doesn't matter that the, aside from the admission of the 0.22 alcohol level, it doesn't matter that that evidence was admitted? Isn't that the only question we've got here?
I think that is the only question, Your Honor, whether this was harmless beyond a reasonable doubt based on the speeding, the reckless driving, and also the 404B prior convictions. And the state would contend...
That's not a separate theory of the jury could have found second-degree murder, is it?
It is. The jury was instructed that they could consider those 404B prior convictions to support malice.
But malice is a separate question from whether there were violations of the motor vehicle laws, isn't it?
That's correct, but the 404B convictions do go to show malice. And like the Court of Appeals majority pointed out, prior driving convictions are admissible to show malice. And the showing of malice in a second-degree murder case is a proper purpose within the meaning of 404B.
Certainly, but I mean, ultimately, we're not looking at is there sufficient evidence. We're looking at what's the likelihood that the outcome at trial would have been different if the inadmissible evidence hadn't been admitted, right?
That's correct, Your Honor, and the state would contend that that standard was met. If it was harmless beyond a reasonable doubt, that standard was met. This wasn't any ordinary speeding. This was the defendant speeding 33 miles per hour over the speed limit. At 1/10 of a second prior to impact, the defendant was speeding 28 miles per hour over the speed limit and did not brake until that point. This was aggressive driving. The defendant was tailgating Mr. Munoz. He passed him in a no passing zone in a curve, and Mr. Munoz had to slam on brakes to allow the defendant to enter back into the lane of travel. All of this was admitted into testimony without objection from the defendant. Plus the convictions that the defendant had, again, three DWI convictions within 3.5 years, and 4 other traffic convictions all show a blatant disregard for highway safety. And because of those reasons, it's the state's contention that because 3 of the 4 malice grounds were supported, that there's no reasonable chance, it's harmless beyond a reasonable doubt that the defendant would have been convicted anyway, regardless of the.
I'm sorry to interrupt you again, but I've heard you say 3 times now, I think, that the evidence was harmless beyond a reasonable doubt. Is the state conceding that that's the appropriate inquiry, whether it's harmless beyond a reasonable doubt?
No, Your Honor, the state is not conceding that. Again, the state doesn't believe that the majority necessarily found that it was a constitutional error, but we would be happy to brief that issue. But the state's position is.
Let me just clarify. Are you saying then that if that is the test, if we conclude that is the test, that the state has satisfied that anyway?
Yes, Your Honor, the state would contend that no matter what the standard, that the state would still win and that the conviction should be affirmed under either standard.
So the state is taking the position that the blood alcohol level would have had no possible effect on the jury's verdict? Is that
That's correct, Your Honor. The test for harmless beyond a reasonable doubt is whether the independent and non-tainted evidence is overwhelming. And here the evidence of the speeding and the reckless driving, which were admitted into evidence without objection, are irrelevant to the impairment issue. And it's the state's position that the defendant would have been convicted on those grounds of speeding, reckless driving, and also taking into consideration all of the 7 convictions on his certified driving record that were admitted into evidence, that the defendant would have been convicted based on all of that evidence without regard to impairment.
Well, if that's the state's position, then how would we reconcile with our decision in the In Re Superior Court order case that this blood evidence was admitted here without the existence of either probable cause or reasonable suspicion?
Well, again, Your Honor, I'm not sure the In Re Superior Court order finds a constitutional error necessarily. Just like I don't believe the Court of Appeals majority in this case found a constitutional error. I don't think that a decision would.
But if the Court of Appeals relied on it, and you're the appellee here in the state's position in this case, then how and why should we ignore that?
Again, Your Honor, I don't think the Court of Appeals majority opinion is necessarily clear. We would be happy to brief that issue about whether the majority did find that this was a constitutional error. It's not very clear. The state would concede that the majority opinion could have filled in a few of the gaps, but we would be happy to brief that issue about whether this was a constitutional error.
Is it the state's position that we should not should we rule in the state's favor in this case that we should not rely on in re superior court order?
I think this court could affirm the convictions based on either standard, just given the fact that the defendant would have been convicted under the other three theories, regardless of the impairment evidence. So because the evidence of speeding and reckless driving were admitted without objection, and the jury was properly instructed on malice, specifically the jury instruction said, if you find that the defendant drove while impaired or drove in excess of the posted speed limit or drove recklessly, as those violations of the law are defined, and that the defendant acted intentionally and recklessly and wantonly as to manifest a mind utterly without regard for human life and social duty and deliberately bent on mischief, it would be your duty to return a verdict of second-degree murder. So the jury was properly instructed on malice, and that this wasn't just an ordinary traffic conviction, that this involved malice, reckless, wantonly, without regard for human life. The jury was properly instructed on that as it relates to these other traffic convictions, and the jury did find the defendant guilty of second-degree murder based on this excessive speeding, 33 miles over the speed limit without braking, the aggressive driving, the passing in a no passing zone on a curve. The jury found those traffic convictions were sufficiently elevated to malice, and the state contends that the defendant would have been convicted of second-degree murder under any of those theories, and also taking into consideration his traffic convictions, and would ask that you affirm the conviction of second-degree murder based under either theory. And if there are no further questions, I'll rest on my brief.
Thank you, counsel. Rebuttal.
If Your Honor, may it please the court, just a couple of points in rebuttal. First, the issue again in this case is not whether the jury was properly instructed. The issue in this case is whether the unconstitutional admission of 0.22 blood alcohol content is harmless beyond a reasonable doubt. That requires the reviewing court to say, did that evidence not contribute to the jury's verdict? Did it not contribute to a finding of malice? And again, I think it's almost incomprehensible to think that a lay jury, considering a blood alcohol content of 0.22, wouldn't have found that to be some evidence of malice, and if so, it contributed to
follow up on that a second, Mr. Whitehouse. Let's say we've got evidence as to what your client's speed was, for example, in the record. Assume, and I'm not wanting to get into a sufficiency issue, so assume for purposes of discussion that the evidence of that speeding would be sufficient to support a finding of malice. Would the 0.22 blood alcohol level be relevant to determining whether the defendant's speeding was or was not malicious, and if so, why or why not?
Yes, I think the question is not whether it would be relevant, I think, so much as
or would it affect, would it be likely to affect what the jury thought about whether malice existed based on the speeding?
Yes, I think it would be something the jury would consider, because they don't have to just find that he was speeding at any particular speed. They have to find that that speeding was done with malice. And again, I think the jury hearing that that speeding occurred when the person had a blood alcohol content almost 3 times the legal limit would have added to the likelihood that the jury would have found malice, that that the speeding was done maliciously. And under Bowman, if it could have contributed to the jury's finding of malice and thereby contributed to the conviction of second-degree murder, it's not harmless beyond a reasonable doubt. So it's very important, I think, for the court to keep in mind that we do have this, I think, rather murky concept of malice. It is what separates murder from manslaughter. It's what separates murder from reckless driving or speeding or unsafe driving. And there's almost there. I think it's again. I keep saying incomprehensible. It's hard for me to see how this court could conclude that evidence of a 0.22 blood alcohol content would not have contributed to the jury's determination of malice. I also want to mention that it's strange to me we're talking about whether this error was constitutional. The state hasn't argued that in this case. And I recognize, Ms. Heathcott's desire to do supplemental briefing, but they've got to get that issue before the court through a petition for discretionary review, because it's not the issue in the dissenting opinion. And so to just do supplemental briefing wouldn't be enough, and I don't think it's called for in this case. Again, the state could have asked for discretionary review on that or other issues. They didn't do that. And finally, with regard to the notion of constitutionality, the Court of Appeals majority does cite in re Superior Court. The Court of Appeals majority cites Romano, which is a case from this court that dealt with the constitutionality of the admission of blood alcohol. It cites McNeil versus Wisconsin, which is a United States Supreme Court decision dealing with that constitutional issue. So although the Court of Appeals majority could have been a little clearer, I think when you see those citations, there's just no, it's in conjunction with the dissenting opinion, there's just no reasonable argument that the Court of Appeals was analyzing this as a constitutional error. Again, state hasn't asked for discretionary review on that issue. We think the issue was preserved, it was ruled on by the court, and the Court of Appeals majority plainly did not use the appropriate standard harmless beyond a reasonable doubt under 1443B in this court's decisions. We would ask that the Court of Appeals be reversed.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.